Yes, Mr.
Before I proceed, Lord, I will request your lordships to have volume 2J. Page 4. And kindly note these, Lord, the definitions of minority, which is from the United Nations General Assembly. Para 10, 11, 12, 13. The first definition is designed by Francesco Capatorti, Italian lawyer who was a representative of the Italy in United Nations General Assembly, which was slightly modified then by the Canadian judge.
Which page?
Page 4.
Yep, volume 2J, that's the additional written submission. Volume 2J, page 4. And in para 12, those definitions find resonance in United Nations Commission for Religious and Linguistic Minorities. I'm sorry, it's the Indian. It's the Indian National Commission for Religious and Linguistic Minorities. And then from Britannica. And this note I had already submitted that is actually flowing from the objective of Article 30, the idea of dominance. Otherwise, Article 30 is not required. And also note at page 9, para 24.
If we go by the question of dominance,
Yes.
may have some repercussions, even may have a lot of repercussions otherwise. But otherwise,
It matters not what repercussion it has. The question is to define. This court has been avoiding definition. So let's define it appropriately, then everything, in every case, it can be applied. Otherwise,
Your approach, Mr. Dwivedi, would be that the conferment or denial of minority status would depend upon the position of the founder in relation to the dominant ruling group, not the position of that minority in relation to the ruling group, but that the founder, for instance, in this case, it may be well conceivable that the Muslims were in fact in a minority, I mean, in the constitutional sense, I'm just using it as a tag. But you are saying that because Sir Syed Ahmad Khan, he became a sub-judge, he was employed in the British East
that's
India
a separate
Company.
argument.
Therefore,
That's
his relationship with the government was not, he didn't consider himself to be a minority.
No, that's a separate argument. That's the third limb.
So it has to be the position of that group.
Correct.
It's a group right. It can't be in relation to the position of the individual,
No,
the rest or.
I'm sorry, Manoj. I said there are three aspects of minority. One was numerical test. The second was the dominance test. The third is, did you consider yourself to it? So that part of the submission pertains to the third limb,
But
not
the
the
dominance
second.
also, dominance would pertain, even if applying your standard, to the entirety of the community. It can't be the dominance in relation to the founder.
Well, sir,
That because the founder was kowtowing to the then powers that
this
be,
is
either in pre or post independence India,
with,
therefore that
with
you
utmost
lose your right.
deference, my lord, minority is a political concept. It relates to somebody, some group which is in majority. It's a political relationship which is now, my lord, enshrined in the constitution in the form of Article 30 for futuristic purposes.
For
Now-
instance, say a political party in a state may regard a particular minority A. I'm not taking any particular name of any minority group. A political party in power in a state may regard that minority as a very valid constituent, a very important constituent of its vote block. Does that mean that therefore, though numerically it is in a minority, or it performs or it fulfills all the indicia of a minority, because it is regarded as a very important ingredient of the ruling bloc, therefore it will be denied minority status under Article 30?
I'm not saying this in
Because this will become subjective then.
No, I'm not saying in the context of the government which of the day. I'm talking in terms of the community which is ruling. We are talking of 1920 when a particular community was ruling to the Governor General. Take the community as a whole. Neither the Muslims nor the Hindus were part of that government. We were subjects alike. And we were equal in the sufferings.
So therefore, both the Hindus and the Muslims would fulfill the indicia of minority status.
No, there's no question of minority. The relationship was of the imperial ruler and the subject. We are all subjects. We are all treated alike. All subjected in the same manner. So there's no question, as the Solicitor General also said, that there's no concept of minority then. We are trying to foist something, my lord, backwards, my lord, on a statute made by an imperial power which was not there. Now, this is just a fiction which we are creating. How do we do it? What principle, my lords? How do we, my lord, extract the principles which this court has laid down over the course of years, my lord, up to TMA and then say that we will apply it to 1920 and then discern, my lord, whether this particular community was.
Because the claims of those who were established pre-independence are also subsumed within Article 30. It's not that because you have been established before independence that you are not entitled to 30.
That's the question which I'm raising for your lordship's consideration. Your lordship may not accept it, but then that has to be decided. Because your lordships, my lords, have at least 5 cases I have cited in.
But therefore, is your contention that because prior to 1947 there was no concept of minority as we constitutionally recognize it today.
Yes.
Therefore, it means that any institution which has been recognized, which has been established before 1947, or really before the advent of the Constitution on 26th of January 1950, no such institution would be entitled to claim minority status. It will boil down to that.
It will boil down to that, my lords. And the only exception which can be drawn, my lord, is a principle where some community was actually a minority, not in power, not in dominant position, like Parsis I gave an instance.
But there again, you say that the whole concept of minority was non-existent before.
Not in existence, but they were in numerically test, and the dependence non-dominance test, if applied, can probably, if we stretch Article 30, it was never meant to apply by any principle backwards, my lords. Just see, there are 5 cases in para 9, para 24, page 9 of the same submission.
Really, there may be some difficulty also because these definitions which you are reading of Western philosophers, etc., or UN, etc., are made in a slightly different context. Whereas when we are referring to Article 29 and 30, we are referring to certain things which are provided in the Constitution. What is in the Constitution itself? Because let's take the example, say the South Africa. The majority community, in fact, was not dominant.
There are numerous examples in
Now, it's also possible, therefore, if that is, if we go into all that, they can be also, they will be difficult. So when they're dealing with that, because here in India, we have given protection to various groups also. Ones which are marginalized, socially marginalized, we have been given protected. There are certain benefits also. Positive affirmation is also there.
That's all right. It doesn't impact that much.
So therefore,
Reservations
when we
are
are
not
referring
impacted.
to, when we are referring to 30, should we apply these definitions over here?
No, this definition is applicable independently. I had made a submission that the object of Article 30 is safeguard, protection.
No, that's a separate
From
argument.
that flows dominance. So this definition is apt. It is in sync with what I have submitted respectfully. That you are numerically less and non-dominant. The problem which your lordships are posing,
Then also dominance can keep on varying from time to time.
no, we are discussing, we are based on a
Let's assume-
constituent.
if you talk about political dominance, it can vary from time to time.
No, now we have a constitution, a republican constitution. Now Article 30 is in the constitution. So we have to proceed with the constitution as from 26 January 1950 onwards. How do you?
And dominance is also a function of socio-economic advancement. What if there's a community which does not have the benefit of education, as the Muslims were at that time? Community which was not highly advanced socially, economically, educationally. These tags of minority status.
From the angle of Western education, everybody was in minority. If this test is applied, nobody had, it all started in 1957. Universities, there were hardly 5. So we were all, my lord, in the same position. It's not that the Hindus, my lord, had Western education and the Muslims did not have.
That may indicate that the constitution as framed did not mean to apply this test of dominance, because otherwise even Hindus were a minority in that.
Constitution has to, my lord, constitution you may not apply or apply, my lord. The point is, how do you apply any principle of Article 30 backwards 30 years ago and even 100 years ago? What are we doing? Well, in 1950, all missionary colleges, which is called, my lord, college period for the missionaries, 1850 to 1900. So what are we doing, my lord? How far we are going back and taking these principles and judging, my lord, their status and giving them, my lord, the imprimatur of 30? Now, if the college is doing good, my lord, why will Parliament or any legislature, my lord, do something which takes away anything from that college? We have to trust the Parliament in that respect. Why extend 30 is the point.
All right, I'll ask you another question. What was that? What change took place on 26th of January 1950 that the Muslims, which according to you would not have minority status before 1950, suddenly acquire that minority status post 1950? What was the big change which took place?
The big change happened was that after, my lord, whatever I had mentioned earlier, the separate electorates, weighted reservations, and this theory of separate nation. 1930, Allama Iqbal repeats in the Agra session of Muslim League. And from 35 to 47, entire Aligarh Muslim University, my lord, barring some exceptional individuals, was pioneering the Pakistan movement. Mr. Sibal, perhaps, or Mr.
What happened on 26th of January 1950, which then elevates
by that time, India stood divided. And therefore, whoever...
But in relation to your threefold test, what is the change which takes place on 26th January 1950?
Change happened that those who were left behind, who had been beguiled into that theory of Pakistan, they were dependent upon a rule of the majority under the Constitution of India, which is likely to be most often of elements from Hindu community.
But presumably even...
So therefore, Lord, they needed,
But presumably even after post-independence, the Constitution assured an equal citizenship to everyone, whether you are a Hindu, Muslim, Jew, Christian, Zoroastrian.
Those who were resident.
We at a constitutional level, we assured an equal citizenship to everyone.
That's right.
right? In which case, how can anyone then claim that I have a minority status? Because this is
of
what the
30.
Constitution assures me.
Because of 30. But for 30, nobody could.
But that begs the question, because what does 30 recognize in terms of a minority?
30 recognizes only this, that you are a group of people who have got subscribed to a different religion, you have a different culture, you subscribe to a different script and language, Urdu, and therefore that needs protection.
But these are sociological features. These are sociological features. And those sociological features existed even prior to 1950.
But it makes no difference whether it existed or did not exist. Before the British came, they were the rulers. It was a question of alliance and loyalty between two rulers of the past. So even if you go back, how many years will we go back? And say, even if 200 years back some school was set up, so minority rulers. The rulers are establishing for dominance over this country, for imperial rules, for exploiting this country, for destroying this country. And whatever constructions were done by them was for their advantage. Incidentally, it flowed to the others. They thought we will produce brown sahibs, but our intellect was such that we produced a renaissance in Bengal and it flowed all over the country. So that was our potential. But their objective was that. However, that's my respectful submission, which your Lordship will examine, kindly, because we are, in no case we are defining, what is a minority. If you don't accept that definition or the definition which I am placing for consideration, there has to be some definition. If you apply see another angle, if you simply apply the numerical test, what happens? Let's take Kerala. Now, nobody is in majority. Let's assume, that there are Hindus, Muslims, and Christians, and each of them are at 33% or 35%, 30%. So how do you apply, decide who is minority? So please define. These cases will come. And the reference requires decision. Now, nobody is in majority in there. It has to be some combination. Christians, Muslim, Hindu, Muslims or Hindu, Christians somewhere. I mean, this electoral politics will play out in its own way. But how will you decide? If you have simply a numerical test, then how do you decide Kerala? Nobody is in above 50%. Nobody is a majority. So we need a definition. Now, it's high time 2024, if we still don't decide the definition of minority, which the framers did not decide. So we need a definition. And we had the best test is objective test. Why was 30 needed? It's a safeguard and a protection. And the next question will be from whom? From the ruling majority. The fear, what was that fear? The whole argument for creating Pakistan was the fear of Hindu domination. We want a separate homeland. So the fear of Hindu domination, which was there, and it lingered. Kindly see what Syed Ahmad Khan says, we have not forgotten and we will not forget. They did not forget in 47 also. Gandhiji pleaded with Jinnah, tell me maximum safeguards, whatever safeguard you want, I am ready to give. Agree to that. He said, we don't want safeguards because safeguards gave us a tag of minority. Whereas if you agree that we are a separate nation, then that idea of minority transmutes itself and we become co-sharers. That's why, in the cabinet mission, they were giving parity at the top, central level. They did not enter the Constituent Assembly, which started on 9th December 1946, because we had declared it will be a republic, democratic republic. Votes will be there. He said, vote doesn't help me. I have got 1 vote, brother Gandhi has 3 votes. So we will never be protected. No safeguard works. So when Pakistan was finally created, then this question was that, all right, this is the safeguard. Article 30. So your fear of dominance of Hindus, this is meant to protect that. That's the objective, my lords, and I would request, my lord, that we can't look at history, my lord. We must look at our history wholesomely. It's not a deprecation, lords. I'm not against Muslims, and all the Muslims in India today have hardly anything to do, my lord, what happened before 1947. So we are all bound by fraternity, otherwise also. So no ill feeling at all. But we must look at the history, and the greater problem arises when we don't look at the history squarely on the face. We want to avoid looking at it, and we ultimately create something which creates more problems. After all, Justice Vanchu and all the learned judges in Aziz Basha are witnesses to what was happening, my lord, all through the two world wars. Justice Vanchu became an IAS officer in 1926. So he's a witness of all that. Salmon Commission and everything, Lord, he knows what was. That's why is he assuming? He doesn't want to go into that question and decides on this established. Because if you decide, go into this, whether Muslims are minority or not, at that time, there are complications. So why go into it? Decide on this basis. And this judgment has operated for a long time. The whole thing, this scenario has changed, to which I'll advert to later on. For the time being, kindly just note, my lord, these judgments which I have mentioned in para 24 of page 9 of the same book, which say that fundamental rights cannot be applied retrospectively. If they cannot be applied retrospectively, then the principles underlying those fundamental rights cannot be applied retrospectively. We can't judge.
Which page were you saying, Mr.?
Para 24, page 9, this volume 2J.
Yes.
The learned solicitor has also, my lord, and is adverted to this. I've given the page and paragraphs. Some of the cases he has elaborated in his written submissions. I'm not reading these cases. It's well settled. But what follows from these judgments which say that fundamental rights cannot be applied? So we say now, fundamental rights will not apply retrospectively, but the spirit, the fundamental, the principles, etc., my lord, we will project it backwards and judge them from that angle today. But no constitutional principle permits that.
Mr. Dwivedi, merely because the circumstances relating to the transaction are partly drawn from the past does not necessarily render the fundamental rights retrospective.
I understand the distinction between.
For instance, suppose we are in 1951. Somebody has acquired a property in 1930. Property has come to a zamindar in 1930. Constitution is born. Property is expropriated. Can that person not assert a right under Article 19(1)(f)?
Yes. Why? The reason I'll tell you, Lordship. Because that property.
Because those certain antecedent elements are drawn from the past, the right, the fundamental right arises on the birth of the Constitution.
That's right.
Likewise, Article 30 is basically a group right. That group right comes to be recognized in the birth of the Constitution.
Provided you had
what does that group right require us to decide? Who establishes and who administers? Now, one way of looking at it was who is establishing it now in 1950? But that would not be a correct reading. Who established this institution on the birth or the founding moment, as they were saying? Now, the founding moment, you therefore look at not for extrapolating the fundamental right back to 1920, not at all, but to look at the circumstances in which that institution was created in the first place.
No, but we are
You
doing
may still
more.
come to the conclusion that it was not created by a minority. It was created by an operation of law, by a statute. That's a separate issue.
No,
but we have to necessarily look, otherwise we'll be artificially restricting the operation of Article 30 only to those institutions which were created post the Constitution. There's nothing intrinsically in the Constitution to deny that assertion of status to those who were in existence prior to it.
So
and
now,
I said, why stop at 30 then? Same thing will apply to 19(1)(f). Same thing will happen to, so apply to a variety of rights. Somebody sets up an industry in 1925. Industry continues. Does that person not have a right under 19(1)(g) on the birth of the Constitution?
Now,
You have a right.
so let's examine this, my lord. Supposing somebody sets up an industry before the Constitution. He had a right to do it. He had set up an institution. He had a property right. That property right, by virtue of Article 395 read with 372, etc., continues. And therefore, the fundamental right he gets from the date. When we come to Article 30, the persons whom we are talking about did not have a right. There should be some right which is being protected and carried on in a different shape, in a higher pedestal. But if there was no right, and it was entirely on the mercy of the Governor General to do or not to give, then, Lord, where is the question, Lord, of sticking this label on them? There was no concept of minority, there was no right of minorities, there was no duties of minorities, no provision. Nobody, and they did not claim that they are minority. Yet, my lord, we are trying to project 30, my lord. So the two examples, my lord, with greatest respect, my lord, rather redound in my favor of my submission. Where you had a right, certainly it will continue and it can be elevated also. But if you had no right, and there was no concept of minority, and you never considered yourself to be minority, rather you rejected it. When it was told to you that you are minority, said no. Finally, just have a lot from the document from the transfer of power, very interesting. Page. Same volume, page 31, written submission. Para 8 at the bottom. I'm sorry, but it's underlined minutes.
Where will you catch it, Mr. Dwivedi?
This volume 2J, which your lordships were having.
Page 31.
This is from the transfer of power.
Yes.
Page 31, para 8. I was therefore led to ask myself, what is this element in Muslim thought which finds expression in Pakistan? It derives, it seemed to me, from a revolt against the allied concepts of minority and safeguards. Experience under the Congress governments may have been the immediate stimulus, but the real motive goes deeper. Nor does it lie in the recognition that safeguards depend for their efficacy upon the presence of a third power to enforce them, a power which will disappear from the Indian scene with the coming of the dominion status. This is something happening relates to 1942. It lies more profoundly, though perhaps less consciously, in the knowledge that safeguards are designed to improve, but cannot radically alter the position of a minority which remains a minority. A Cinderella with trade union rights and a radio in the kitchen, but still below stairs. It is against this whole combination of ideas that Muslim mind rebels. The two-nation theory, which transmutes the ideology of minorities, is thus more fundamental to their present thought than the Pakistan theory, which transmutes the ideology of safeguards. From this new outlook of Muslims, there will obviously be no retreat. My conversations have therefore indicated that it is misleading to approach the general Muslim problem in terms of the same phraseology as we use about the interest of minorities, like the Europeans, depressed classes, and so on. Some new terminology is needed to keep our consideration of this problem on the right lines. Terminology which recognizes the problem is one of sharing of power rather than qualifying the terms on which power is exercised by a majority. And also, at page 38, so both the Muslims and the ruling power of the time considered them to be a nation. They rejected minority. And we are trying to give that imprint. Kindly have the last page at page 38. The third line. That was the time, Lord, when Chiang Kai-shek was visiting India. When the INA forces had marched and reached Imphal, my lords. The third line, India is not one national state. It's two major nations being Hindus and Muslims, and 1/3 of India is under the princes. So unlike the case of industry and property, etc., my lord, where the rights were in existence and our constitution transmutes it into a higher level, protected it by fundamental rights under 1940. But here, something which they are rejecting, which don't agree with, we are then by 30, my lord. This is all past part of history. I can multiply number of documents, Lord, but this is just to give an idea, Lord, about what they were thinking. The person who's said to be the founder, his ideas, Lord, of separate nation continued to grip AMU. That is why, Lord, what was told to your Lordship that when the President, or at that time Vice Chancellor Zakir Hussain, Lord, visited, he said that the future will depend upon how Aligarh looks to India. That was what was told to your Lordship from the appellant side. Why was this said? Because Aligarh was with Pakistan movement. And a large number of students and teachers all migrated to Pakistan also. So these are facts, Lord. I don't think, Lord, that it should be inconvenient to any person that this is being stated, but because we must face the truth and then see whether 30 can still be applied.
Yes, Mr. Dedi.
Now, kindly have the main volume, Melodies of my submission to H. Before page 8. For a Lordship's convenience, I will not read all of this, Melodies, but this is from the Woods Dispatch. Which we have enclosed as R1. I have extracted the relevant portion.
Page
8, paragraph 11B. 11A is Macaulay's extract. That minutes of Macaulay is also enclosed as R6. Page 9 is the relevant portion, Muller. That is para 35.
5H.
The 11B at page 8. And kindly come to these full documents are in volume 5H.
Where will you get the volume?
5H. Because the Hunter Commission, etc., is pretty thick volume, so we separately. All these documents in this written submission are separately compiled in 5H. Now please turn to page 9. Para 35 from that document, Wood's dispatch. We shall be ready to sanction the creation of an university at Madras or in any other part of India where a sufficient number of institutions exist from which properly qualified candidates for degrees could be supplied. It being, in our opinion, advisable that the great centers of European government and civilization in India should possess universities similar in character to those which will now be founded. As soon as the extension of a liberal education shows that their establishment would be of advantage to the native communities. Now, both the words founded and establishment are simultaneously being used, and the objectives are similar. Now, please turn to page 11. D. So, para D. Between 1857 and 1882, no other university had been established. The Hunter Commission was appointed by resolution of Government of India dated 3rd of February 1882 to review the progress of English education made in India. Specific instructions were given to the Commission with respect to primary education, secondary education, and colleges to examine further involvement of private efforts under the grant in aid system. That is Hunter Commission report, para 10, page 626. It is noted in the report of the Commission that after the disappearance of British East India Company, the principles of dispatch of 1854 had been confirmed by the Secretary of State in the dispatch of 1859. In para 46 of the report related to the Indian universities, the same is quoted below. Now see at page 12, the last bold lines of this sub-para D. This is regarding Lahore. Dr. Leitner was a very prominent place. It is mainly an examining body, but exercises variety of functions for the promotion of literature and education. Its distinguishing features are that it owns its origin to other than state efforts, and that is designed to give special encouragement to Oriental studies. So somebody or the other obviously will go and request that Now we need in the northwest frontier provinces, we need a university. There's no university. So merely because somebody is requesting, contributing some little thing, yes, ma'am. So therefore, my lords, at that time, there was no policy. That's what I had submitted, and these documents show that up to the level of college, private efforts, grant in aid, otherwise there was no policy. Now with Lord, may I now move on to some 2-3 aspects of the Act only, because almost everything has been covered, so I don't want to retrace all those things. If your Lordship has Volume 4C,
Volume 4C, Mr. Dwivedi?
4C, page 40.
In this case, who are the two nodal counsel actually? You're the. If you can just overnight, maybe give us a master index, like we had in Article 370, with Act to be found in this. The documents you can give us a master index, then the judgments. So Basha, other judgments, which are the volumes. So it becomes easier when you are dictating in the end, or even to read it before the, as we go along. Just put it in a plastic, or just on any paper, and we'll give it to the court master, so he'll circulate to all 5 of us. Yes.
Page 40, at the bottom, Mr. Shafi, who's introducing the bill, he is a member of the council, executive council. Sir, I beg to introduce the bill to establish and incorporate a teaching and residential Muslim university at Aligarh, and to move that bill be referred to a select committee consisting of the Honorable George Lowndes, the Honorable so-and-so, Raja of Mahmudabad. There were 5 British persons in this select committee and 5 other gentlemen. Raja Mahmudabad, Asad Ali, Khan Sahib, Shahnawaz Bhutto. I hope not this name rings some bell. He is the father of the Prime Minister of Pakistan,
of Mr. Zulfikar
Ali Bhutto. And this something more very significant. All these 5 gentlemen ultimately were Pakistan supporters. And Shahnawaz Bhutto is the person who in January 1947 came from Karachi and became the Diwan of Junagadh, Nawab Junagadh. The Nawab himself, was holidaying in London. Mountbatten never summoned him for accession like he was doing with all others on 3 subjects. He comes back, Nawab comes back on 11th of August and signs accession in favor of Pakistan. And along with his numerous dogs, he vanishes to Karachi. Shahnawaz Bhutto continued there to rule.
In Junagadh.
From Junagadh. And when this accession happened to Pakistan, then there were 2 other principalities, that is Mangrol and Babariyawad, which had been attached during World War with Junagadh. So they declared independence and acceded to India. Then Shahnawaz Bhutto sent his forces to occupy Babariyawad in Junagadh. Then, cutting the other part of the story short, what happens is that Indian forces are sent, which take back and surround Junagadh. It is then that Shahnawaz Bhutto, through the sea route, vanishes to Karachi, and the Junagadh was regained. So these are all forces, all these 5 gentlemen went there. In the negotiating team, M.A. Jinnah was also involved, which was negotiating the bill. And he was one of the persons who said that now, since it's it's all India importance university, therefore, instead of Lieutenant Governor of Northwest Province, it will be befitting to have the Governor General as Lord Rector. So this is one aspect which I wanted to point out to your lordships, that the British, in the scenario of Rowlatt Act 1919 and Khilafat movement, the discovery of oil in the Middle East and obtaining of the mandate in Palestine by the British imperialists, all these circumstances, certain things were being done by the HMG and the Governor General, which is known to everybody. Drive a wedge. You will find at the next page 41 bottom that this process began in 1911. The request. And it was granted only when they agreed to BHU in 1919. It took them 8 years to have that act. This is one aspect, my lords. The second aspect is, my lord, what is the significance of this office of Lord Rector? None of the universities which were created, established by the Governor General in Council, had this office of Lord Rector. We were told by the appellant's side, my lord, that all universities have got visitors. So what is so great about it? There are visitors, there are chancellors, vice chancellors, there's some supervision, some regulation. So now I'm trying to, my lord, make an effort to apply these principles of 30 backwards and see what's the consequence. Can we say that it was established by the minority? This special office of Lord Rector and Governor General as Lord Rector was only in these two universities, BHU and Aligarh Muslim University. The second feature is that unlike the visitors, even in the acts passed subsequent to the independence under the Constitution of India, the visitors have a very limited power of supervising, causing an inspection to happen and giving a show cause, giving some advice and directions. Nothing else. No visitor in no university, public or private, has got a power to make, approve, amend, modify statutes, ordinances. So in contrast to the visitor, the Lord Rector has very wide powers. One, the first statute and the first ordinances are all made by the Governor General in Council. And no amendment can be enforced merely at the will of the court or the visitor's body, visiting board. It must get the approval. So ultimately, amendment can happen only at the will of the Governor General and nobody else, the Lord Rector. The statutes, the third, my lord, the statutes and the ordinances are the life and soul of a university. All universities function in accordance with that. The Aligarh Muslim University Act provides specifically that admissions will happen in accordance with the statutes and accordance with the ordinances. All policies in accordance with statute and ordinances. The court meets once in a year. Where is the control in the court? merely because the name has Muslims and the court has Muslims and de facto there have been Muslims. It's all fine, well, no problem. Nobody has problem with that. Muslims are also Indian citizens, like anybody else. So if the majority of students there have been are Muslims, so Muslim vice chancellor and can be appointed, but that doesn't mean that they have established, therefore we take it again back. This de facto is also rolled back to 1920 to find out the establishment. As I submitted, the main part of the establishment under Article 30 is the framing of the scheme of administration. Please mark the words, right to establish and administer. The right to administer has to be in accordance with the scheme of administration which happens with establishment.
But then aren't you drawing distinction between administration and legislation part in your own argument itself?
No, there's no contradiction. With great respect, my lord. When you establish a university, supposing, my lord, let's take a hypothetical case. Today we establish a university, the law comes, X university is established, there's no framework. This is what happened in Yashpal. The appellants rely upon Yashpal. In Yashpal, my lord, by notifications under Act, my lord, universities were established, there was the shop. X university established in this shop, Y in that shop, and third in this house. No infrastructure, nothing. The court says no. If private people are establishing, then there must be infrastructure, there must be faculty, there must be all minimum rooms, etc., for where students will study. And until that is done, it cannot be incorporated. So what happened there was just incorporation of shops and houses and also on, and piece of open land university established. Government, they said, may do that because government has obligations, constitutional obligations. It will establish, it has funds and everything. But one must know, there are no university shops. Therefore, when you establish a university, the scheme of administration has to be part of it. Who is going to be chancellor? Who is going to be vice chancellor? How principal will be appointed? How employees will be appointed? How students will be admitted? How discipline will be maintained? So there has to be a framework. And that is what Justice Vanchu's judgment, Lord Aziz Basha's does. It looks into all the provisions and finds that the entire scheme of administration has been provided by the Act. Their role in the framing of the scheme of administration is very minimal in non-essential parts. Otherwise, BHU framework was there, you have to follow that. Some little changes were done because university became a central subject. So this rector, my lord, is a concept borrowed from the London universities, especially the 1858 Act where Scotland University was formed. From there, my lords, they took this. And rector, my lord, is considered to be a leader of the university. So this is not a mere change of nomenclature that instead of visitor, we are having rector. And who is made, my lord? Lord Rector. That's added upon it, the Governor General, the supreme power on the soil of India. Nothing prevented the Governor General and Council from saying, my lord, that this MAO college is MAO university, as it is. And asking them to make some changes about visitors, etc. And just as today, the private universities are being formed. They could do anything. There was nobody to question, no judicial review. But they don't do it. They keep the power and entitlement to establish university to themselves. And this is the Lord Rector, Lord, which is provided. Entire scheme is generated from having the source in the Lord Rector. the Governor General in Council, with the sanction of HMG. Before this was established, sanction was taken from the Secretary of State in London. One last thing about this, my lord, is look at the court also, my lords. Volume 2B, my lord, in Solicitor General's submission. The Lordship will not find the 124 members are the founder members. In the statute, the Act says members will be as per the statute. The statute has ordinary members and founder members.
Which page are you reading?
I'm just giving that one the six statute number. Members wala kaun sa hai? Yes, kindly have statute number 8, which is at page 160. Class 1 is ex officio members. Class 2 is foundation members. Class 3 is life members. And class 4 is ordinary members. Now kindly come to the annexure, my lord, which is containing the names of the page 167. There's hardly any connect with the MAO college. It's past students, past teachers, or those who were from all over India, from even Indian states. The Nawabs are members, retired director of public instruction. Almost half of them are in the service of British government in different parts of the countries, from northwest to Bengal and from Kerala to here. Not one person. Some of them are even judges, 46 judges have High Court, district judges, magistrates. 79 is Nawab Justice Sir Syed Shamsul Huda, High Court, Calcutta. So all over the place. Item 81, Muhammad Ali Jinnah. People from Karachi, Punjab and all. 124 members in all. These founder members, Lord, are supposed to, under the statute, retire, like in Rajya Sabha, Lord, 1/5 retires every year. And so for at least after 5 years, 6th year, 7th year, 8th year, 9th year, like that, they will retire. So for 10 years, this is the founder members court. So they are Muslims, all right, but nothing to do with MAO.
They were all trustees of the MAO college,
All of them
all of them.
cannot.
Yes.
You show it.
Most of the facts they give are wrong, but then
You place the correct facts. Now with this, my lords, the last submission which I would like to place is about stare decisis, my lord. Stare decisis. Hmm.
What do you have to say on stare decisis?
Lord, before this, just a reference, Lord, in one of the queries, Lord, of my lords, there was allusion to a legally positive approach, my lord, in this, my lord. Or the submission is, my lord, that legal positivism, my lord, does not involve any retrospectivity. It only, my lord, is concerned with infusing whether moral principles, my lord, can be utilized to interpret statutes, my lord. So various authors, in any case, my lord, the gods of legal positivism, my lords, are not at one. They are varied and in conflict. So very difficult to choose, my lord. However, my lords, the best approach could be of Hart, my lord, or Austin. But that also it's limited to infusing moral principles. Our court, my lord, I have given the judgments at page 9 of my additional submission, where the lordships have rejected the infusion of moral principles. However, my lord, today we are talking about constitutional morality, etc. So at the highest, my lord, even if we have to infuse and inject the principles of constitutional morality and drawn from the provisions of the Constitution, it would be to interpret, my lord, the act. But we are faced with an entirely different question. Therefore, that approach, in my respectful submission, with utmost deference, my lord, may not be appropriate. With this, I come to stare decisis. Lord, my submission is, as Solicitor General has already indicated, Lord, this is a stand-alone university. The act, stand-alone act, creating a university of the kind it is. The judgment in Aziz Basha is statute specific. It analyzes the particular act and comes to a certain conclusion. The third, my lord, is then the act was first amended in 1951 and then in 1965. Some individuals had come to the court. The Aligarh Muslim University never intervened. And it had no problem with Aziz Basha, at least on the judicial side. They may be trying to get changes through parliament. Which obviously has to proceed on the footing that the judgment is good and we have to alter the basis, etc. And whether they have succeeded or not is a different question. But the parliament also will proceed on the footing that the judgment is good and how to change the basis. Now, this judgment, my lords, being statute specific and concerning one university, has been implemented by the government for a long period of time. On the basis that it is not a minority institution.
On factual aspect, was there any reservation or preference given to the Muslims right from 1950 till 1981?
It's after 81 that this order was passed, which was challenged in the High Court.
No, I'm talking about from
No,
1950
not
till
my knowledge, my lord, subject to correction by the other side. Actually, it wasn't required, my lord, because 80% already they were admitting. My lord. So
No, but was there any preference being given, or by even if there was no preference being given,
no policy of reservation.
there was no policy of
That's subject to correction from the other side.
after 81?
After 81, this order came in 85, reserving 50%,
And
which was questioned. 2005. 2005, I'm sorry.
because what was said by, I think it was stated by them, preference was being given to the schools which were affiliated to the AME. And they were giving preference in admissions in the college itself.
So not perhaps in a formal way, but yeah, they were controlling lots. They were principals and all those. So therefore, they were admitting that way. That's what de facto submission is, Milord, that the vice chancellors were there, the principal was there, and so on.
You show me the one on Islamic trustees.
So now this judgment, Milords, has been implemented. Now, please see, Milord, when MAO asked the Governor General to establish the university, what was their contribution in the MAO college? Look at the establishment today, which was shown to your lordships. It's not the same thing. 74 acres of land. And now, Lords, it is having 1,150 acres of land. The government of India is in today's budget is 1,000 crores. There are today 17 halls, all subject to corrections. My learned friend will say it's all incorrect facts. 7-story building. So there's a complete metamorphosis. It's no more that MAO college. What are we looking at? What are we wanting to change? This judgment in Aziz Basha has no impact on any other university which were created before. This is a one standalone university. So what are we wanting to do today? I can understand that this judgment is creating havoc with respect to minorities or something. There's no great public interest involved. Rather, all this money which has been invested by the governments in this institute on the understanding of Aziz Basha's position. Now that can't be taken away now, so we take back all those buildings, etc. You go and establish. Nobody has the right to a grant. There may well be, my lord, consequences which are adverse. So there's no public mischief happening. And I have, my lord, mentioned certain judgments. Page 6. At page 56 of volume 2H. Para 53 to 59. शेरवाई किसमें है? Kindly have para 58 minutes.
Which page?
Page 57, para 58. It's a quotation from Vaman Rao. The principle of stare decisis is also firmly rooted in American jurisprudence. It is recorded as a rule of policy which promotes predictability, certainty, uniformity, and stability. The legal system, it is said, should furnish a clear guide for conduct so that people may plan their affairs with assurance against surprise. It is important to further fair and expeditious adjudication by eliminating the need to relitigate every proposition in every case. When the weight of the volume of the decision on a point of general public importance is heavy enough, courts are inclined to abide by the rule of stare decisis, leaving it to the legislature to change long-standing precedents if it so thinks fit, expedient, or necessary. In Bernard so-and-so, Justice Pandey stated that stare decisis is usually a wise policy because in most matters it is more important that the applicable rule of law be settled than it be settled right. 38, while dealing with the subject of stare decisis, Shri H.M. Sirvai, in his book on constitutional law, has pointed out how important it is for judges to conform to a certain measure of discipline so that decisions of old standing are not overruled for the reason merely that another view of the matter could also be taken. The learned author has cited an Australian case in which it was said that though the court has the power to reconsider its own decision, that should not be done upon a mere suggestion that some or all of it, the members of the latter court may arrive at a different conclusion if the matter were res integra, the Tramway's case. The learned author then refers to two cases of our Supreme Court in which the importance of adherence to precedents was stressed. Justice Jagannath Das said in the Bengal immunity case that the finality of the decisions of Supreme Court, which is the court of last resort, will be greatly weakened and much mischief open to reconsideration. Much mischief done if we treat our own judgments, even though recent, as open to reconsideration. Justice Sinha said in the same case that if the Supreme Court were to review its own previous decisions simply on the ground that another view was possible, that litigant public may be encouraged to think always worthwhile taking a chance with the highest court of the land. Justice Hegde said in his dissenting judgment that the Supreme Court should not overrule its decisions except under compelling circumstances. It is only when the court is fully convinced that public interest of a substantial character would be jeopardized by a previous decision that the court should overrule that decision. Reconsideration of the earlier decisions, according to the learned judge, should be confined to questions of great public importance. Legal problems should not be treated as mere subjects for mental exercise. An earlier decision may therefore be overruled only if the court comes to the conclusion it's manifestly wrong, not upon a mere suggestion that if the matter were res integra members of so. Some other judgments are there, my lord, which I will not read on the same vein. Now, therefore, my lord, in this case, I submit that there is greater public mischief to happen if Aziz Basha is even, my lord, reconsidered and possibly overruled, my lords. Rather than if this is sustained, it has no impact on any other. There is no other past act, my lord, of made by the Governor General in Council. So it has no other impact on trickle down effect. Why we should not, what are we looking for in this? No other benefit, and it's a judgment which has, we are now, what, 1968, 32 and 24, 56 years down the line. And for a standalone case, which ultimately would result in all this creation at the cost of public expense to be handed over to. And lastly, my lords, as I said, there is a distinction between established by, established for. In the worst case scenario, even we look at the title Muslim University and the court Muslim, it would at the highest be a case where the Governor General is establishing the university for the Muslims. I have given in my written submission cases on by or under. By means directly by the provision of the act. And under will be something like this deemed university. Section 3 UGC Act, where we apply with all my infrastructure, everything, degree college is functioning, education level is high. And then the UGC recommends and government then sanctions and you are deemed to be university. That is. And finally, this statute of recognition and statute of establishment. Aligarh Muslim University Act is a statute of establishment of university, not a case where the statute is merely recognizing some college which is already of the standard of a university. While establishing a university, the power that be can always infuse something from those people who are contributing. Sometimes they may be made trustee, sometimes they may be made some rector or something which is decorative positions, patrons, and so on. And even if we have to deal with the judgments, Patro, etc., they are all judgments, Saint Xavier, etc., which is the judgments which are of colleges and schools. So there's no question, none of those cases were considering, they have all noted. I have pointed out that Aziz Basha has been noted in at least half a dozen cases. And even St. Stephen's accepts the definition which has been accepted by Justice Vanchu. I have quoted that portion in my speech. Yes, sir.
Thank you, Mr.
I'm
Devi.
grateful.
Thank you, Mr. Devi. Yes, Mr. Kaur.
Yes, sir.
Hello, I'll concentrate on three aspects. One is the scope of reference and why it's important for your lodges to see that neither is Basha under review or in appeal. And I'll show the reference order in three crucial orders by never ever in 56 years, even remotely, the correctness of Basha on the issue of AMU being established and administered has ever been questioned. The only question in the reference order which said remains undetermined or is yet to be determined is only with regard to the conjunctive or disjunctive reading of established and administered under Article 30, subclause 1. That's the first limb of my argument. In the second limb of my argument, my lords, I will refer to the judgments because a question which was never framed is sought to be framed by the appellants in their written submissions to say there are internal contradictory findings in Basha. That's their question they frame. And then go on to say that this is contrary to various judgments of the Supreme Court to show that that is an attempt to unravel Basha completely when there is no contradiction with the 6 judgments that they cite. That will be the second limb of my argument. And the third will, of course, be 3 or 4 principal submissions established through by, was the act really seeking to overrule Basha? Was it a validating act? Just 3 or 4 crucial submissions I'll deal with in the end. Now, first of all, my lords, Aziz Basha was the result of 5 writ petitions challenging the constitutionality of the 1951 Amendment Act and the 1965 Amendment Act. The challenge was principally based on Article 30, subclause 1 of the Constitution. And the petitioner's case in that matter was that AMU was established by Muslim minority, and therefore the Muslims had the right to administer it, was their case. And they contended that the 1951 and 65 Acts took away or abridged the administrative rights of the Muslims, and thus the acts were ultra vires Article 30, subclause 1. Now, the Supreme Court, my lords, distinctly on three different issues held. As far as administer and established is concerned, it was held, as also held in St. Stephen's later, that they have to be read conjunctively and not disjunctively. The second finding was that AMU was not established by a Muslim minority, but by the central government of the day. And thirdly, AMU was not administered by Muslim minority. The latter two, as I show the next few cases or four cases, never ever have been the subject matter of any discussion or being referred to a larger bench at all. It's all been about disjunctive versus conjunctive. Then came, my lords, the two-judge bench decision in Anjuman-e-Rahmaniya versus the district inspector. Now, what had happened was the people who had set up the society, some were Muslims and some were non-Muslims in that case. So the issue which arose in Anjuman-e-Rahmaniya was whether protection under Article 30, subclause 1 will be granted to an institution which has not solely been established by a minority. That was the one issue they were grappling with in that. And the other issue was regarding whether registration of a society under the Society Registration Act changes the status of the society from a minority institution to a non-minority institution. These were the two issues being dealt with in that judgment. It was in that context, they never disagreed with Basha, they never doubted Basha in any form. They referred it to 7 judges saying that we need to decide on the issue of essential conditions and ingredients of a minority institution should be decided once and for all. That was the basis of Rahmaniya. Now, as I respectfully submitted, my lords, nowhere was the findings in Aziz Basha regarding either establishment of AMU or administering of AMU ever questioned in this judgment. And they pertain to minority societies, not universities, that judgment. Then came TMA Pi Foundation, which dealt with the scope of minorities to deal with and administer an institution, and if aid is given, what are the nature of regulations which can be imposed, regulatory in nature, conditions that could be imposed. Therein, my lords, a question came to be framed, que Rahmaniya. And that question is the question 3 subclause A, which the reference order also refers to, and says that this was the question que Rahmaniya, which was framed in TMA Pi. And that question specifically, my lord said, would your lordships want to see that, or should I just read that out? Yes. What are the indicia for treating an educational institution as a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by a persons belonging to a religious or linguistic minority, or it's being administered by persons belonging to a religious or linguistic minority? And then they went on to say this question need not be answered by this bench. It will be dealt with by a regular bench. So the question was indicia and thereafter conjunctive or disjunctive. Whether AMU was administered by a Muslim minority, established by a Muslim minority, never ever questioned. TMA Pi again never questioned, in fact discussed, and then I come to TMA Pi, not for a second doubts what Basha said. Thereafter, my lords, while disposing of Anjuman-e-Rahmaniya, all that the judgment did, the two judges did, was that now TMA Pi is the law. All regulations, all orders, enactments, schemes, regulations will abide by TMA Pi. And if any question arises in future, it will be decided in the context of TMA Pi, and Rahmaniya came to be disposed of. Then came, my lords, the second reference order of 12th of February 2019, and that I'll request your lordships to please have once more, the reference order. Volume 3A, page 216. Yes, yes. Volume 3A, page 216. This court in S. Aziz Basha and another versus Union of India, inter alia, has observed as follows. It is to our mind quite clear that Article 30, subclause 1 postulates that the religious community will have the right to establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though the religious minority may not have established the educational institution, it will have the right to administer it, if by some process it had been administering the same before the Constitution came into force. We are not prepared to accept this argument. The article, in our opinion, clearly shows that the minority will have the right to administer educational institutions of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by somebody else, any religious minority would have the right to administer it, and because for some reason or other, it might have been administering it before the Constitution came into force. The words establish and administer in the article must be read conjunctively, and so read, it gives the right to the minority to administer an educational institution, provided it has been established by it. We are of the opinion that nothing in that case justifies the contention raised on behalf of the petitioners that the minorities would have the right to administer an educational institution, even though the institution may not have been established by them. The two words in Article 30, subclause 1 must be read together, and so read, the article gives the right to the minority to administer institutions established by it. If the educational institution has not been established by a minority, it cannot claim the right to administer it under Article 30, subclause 1. The judgment of the Allahabad High Court, which is under challenge in the present appeals, rejects the prayers made on account of the decision of this court in S. Aziz Basha Supra. The issue arising in S. Aziz Basha Supra was referred to a 7 judges bench by an order of this court dated 26 November 1981, passed in writ petition so-and-so Anjumane Rahmania versus District Inspector. The aforesaid writ petitions, that is writ petition number so-and-so, were heard along with other connected cases, TMA Pai versus State of Karnataka, by a bench of 11 judges, the judgment in which cases is reported as so-and-so. The question 3A, which was formulated for an answer in TMA5 Foundation, which coincidentally reflects the question referred by the order of this court dated 26 November 1981, passed in writ petition number so-and-so, is as follows. 3A. What are the indicia for the treating an educational institution as a minority educational institution? Would an institution be regarded as a minority educational institution because it was established by a person belonging to a religious or linguistic minority, or it's being administered by a person belonging to a religious or linguistic minority? However, the bench did not answer the question, stating that it will be dealt with by the regular bench. The order of the regular bench, passed on 11th March 2003, which for reasons that we need not dilate, did not answer the aforesaid question 3A formulated in TMA Pi Foundation Supra. The said facts would show that the correctness of the question arising from the decision of this court in Aziz Basha Supra has remained undetermined. That apart, the decision of this court and Professor Yashpal and another versus State of Chhattisgarh and another, and the amendment of the National Commission for Minority Education Institution Act 2004 made in the year 2010 would also require an authoritative pronouncement on the aforesaid questions formulated and set out above. Besides the correctness of the view expressed in the judgment of this court in Aziz Basha, which has been extracted above. Ordinarily and in the normal course, the judicial...
Just read this paragraph once again.
9?
Yes, for your argument. Just
9.
for first argument of yours.
9. Lodges wants me to read 9 again?
Yes.
That apart, the decision of this court and Professor Yashpal and another...
Now, what was Professor Yashpal?
Can I complete the para and then I'll answer that question.
Okay, fair enough.
Versus State of Chhattisgarh and others, and the amendment of the National Commission for Minority Educational Institutions Act 2004, made in the year 2010, would also require an authoritative pronouncement on the aforesaid question formulated as set out above. besides the correctness of the view expressed in the judgment of this court, and Aziz Basha, which has been extracted above. Now, my lords, the reason specific.
This paragraph refers to three things. One is the effect of Professor Yashpal.
Yes.
What did Yashpal deal with? And therefore, the issue which arises.
Right.
Second, it says amendment to the National Commission on Minority Education Act 2004.
Right. Right.
In 2010,
Right.
the second question.
Right.
The third question is with regard to correctness of the view expressed in the judgment of Aziz Basha.
Absolutely right. Now, let me answer that. So, what are the three things?
Basha expected above. Therefore,
No.
Yes.
Aziz Basha expected above.
Yes. So, the question is administered and established and administered, or established or administered is the Aziz Basha question. Why is Yashpal mentioned here? I put a question to myself. Yashpal is mentioned here because Yashpal had the provision under section 2F of the UGC Act, which said establish or incorporated. And they said in this context, it will have to be seen whether it is established or incorporated or established and incorporated. Because if your lordships will recollect in Yashpal, as Mr. Dwivedi also rightly pointed out, if you were to set up these one-room tenements all over as universities, all over the place, and then say, I have incorporated a university, that's a university, they said, no, you must have infrastructure, you must have facilities. So first establish and simultaneously incorporate. And that is why the word establish or incorporate, like administer and or incorporate or and administer and establish came into being. Most pertinent here is the amendment of the National Commission for Minority Educational Institutions Act 2004, because here the words used earlier were administer or establish, which by the 2010 amendment were replaced by administer or establish and administer. So that is why, keeping in mind that the question which in Aziz Basha remained undetermined was disjunctive or conjunctive, that is under Article 30 subclause 1, is it established and administered or established or administered? Similarly in Yashpal, the finding on established or incorporated, or should it be read as established and incorporated as in Yashpal? And more importantly, in the NCMEI Act, where the 2010 amendment changed the words from established or administered to established and administered, was the context that this had to be seen. My respectful submission in that light is that what your lordships are today being asked to decide on the basis of questions which have been framed by the appellants, not by the reference court, because the question they choose to frame, or one of the questions they choose to frame is that whether the decision in Aziz Basha is internally contradictory in its reasoning on facts and in law, contrary to the authoritative decisions of this court rendered nugatory by subsequent statutory changes, and contrary to the constitutional dispensation of Articles 29 and 30. Now, my lords, would your lordships, I'm not for a minute saying that a bench of 7 judges cannot frame an additional question or the contours cannot be decided. But would your lordships ever in these matters go into an appeal, go into a review of a judgment who has been settled for 56 years and never questioned at all in any decision, not once doubted on the two issues of AMU being administered and the AMU being established? On both questions, their findings never doubted. And the only question which arose was, is it to be read as or and that is what gets referred. And that is why the reference order in para 8 uses the word not in plural. It says the question in Basha. It doesn't say the questions in Basha, because the only question which arose was the question of disjunctive or conjunctive, not all the three issues, because Basha ultimately decided three issues: administer, establish and administer, or establish or administer. And St. Stephens, of course, followed that finding and said that it has to be conjunctively read, not disjunctively. So our respectful submission, my lords, also linking this argument to the last argument of Mr. Dwivedi on stare decisis is that would your lordships today, when neither does any court ever doubt the decision, and I'll go through those decisions today or tomorrow when I again commence my arguments, then none of those decisions, whether Mother Provincial, St. Stephens, TMA Pi, A, their facts have no bearing on Bhasha at all. At all. Secondly, not one of them even remotely has questioned the correctness of Bhasha at any stage in any form. On the issue of administer and establishment of AMU as an institution, not by a minority as held in Aziz Bhasha. I'll recommence tomorrow morning.